Say hi to James and John, a happy Ohio couple who just got married in Maryland. Because Ohio's marriage laws didn't recognize same-sex couples, they had to get married in a state that did recognize them. Sadly, a little while later, John died. Distraught, James wanted to get his name on his husband's death certificate. To his surprise, the court said no, claiming that they didn't have to recognize marriages from other states. Obviously, this made James upset, so he took them to court trying to appeal this decision. The court sided with James, somewhat. Turns out Theodore Winslow, the Ohio director of the Department of Health, pushed for an appeal against the court's ruling. He believed marriage was up to the states, not the US government. While this was all happening, 5 other similar cases were occurring. This case, along with 4 of the 6 similar cases, were sent to the 6th Court of Appeals, the next step up the ladder. The case was later named Obergefell v. Hodges. Sadly, they too said no, leading to a push for another appeal. After hearing this, those involved in the original 6 cases appealed to the Supreme Court. They urged the court to consider if the previous decision violated the due process and equal protection sections of the 14th Amendment. Later, questions regarding same-sex marriage were included in the appeal. A few months later, the Supreme Court came to a consensus. A 4-5 vote decided that same-sex marriage was protected under the 14th Amendment and should be therefore allowed countrywide. Finally, after all the years in court cases, James got his name on his husband's death certificate. Thanks to the decision of the Supreme Court, people across the country are able to marry who they want, and states are required to recognize marriages out of their state. The end.